Hi, welcome to ADL's 20th Annual Supreme Court Review. I'm the mic tester for you all, so you can hear I'm a little loud. I'm Melissa Garlick, ADL's Civil Rights National Counsel, and I'm honored to be moderating this program once again. We are very excited to be broadcasting live from the National Constitution Center in Philadelphia for the 7th consecutive year, particularly after this transitional term of the Supreme Court, where again, much was and continues to be at stake. I want to thank the staff here at the National Constitution Center, particularly Jeffrey Rosen and Tanaya Tauber, who have worked tirelessly behind the scenes to make today possible. We're grateful for their partnership year after year. And I have the distinct pleasure of being on the stage with our distinguished and impressive panelists, from whom we are all very excited to hear. But before, I just want to recognize the amazing group of lawyers, counsels, and policy staff, as well as lay leaders who led in filing the briefs we'll be talking about today. Some of them are in the room. ADL Senior Vice President of Policy, Eileen Hirschnoff, Vice President of Civil Rights, Steve Freeman, Washington Counsel, Michael Lieberman, Director of Federal Relations, Moran Benai, National Policy Counsel, Lauren Kropf, and Northeast Civil Rights Area Counsel, Amy Feinman. I also want to recognize our National Civil Rights Committee Chair, John Harris, who's here today. There are so many people working behind the scenes at ADL to make today possible, but a special thank you to Nancy Baron-Bear, our Philadelphia Regional Director, Carol Goldstein, Alana Rosenbaum, Jared Windler, Lila Fuhrer, our entire web and video team who made sure that all of you around the country can watch this live streaming. And I particularly want to give a shout out to the Philadelphia region. Just here in the Philadelphia region, 19 different sites are hosting live streaming watch events today. So we're really excited about all the events that are hosting around the country. Before we get started, just a tiny bit of housekeeping. For those of you seeking CLE credits, there will be 2 codes that scroll across the bottom of the screen at different times during the program. If you're watching at the live stream, please make a note of those codes on the evaluation forms you should have received. For those watching on your own computer, you should have received that form via email with a link to the evaluation form. To receive CLE credit, you need to fill in the CLE codes on that form and submit it. If you're watching at an ADL event, please fill in those codes in the evaluation forms and submit them to staff. For those of you who are here at the National Constitution Center and are seeking CLE credit in Pennsylvania, if you didn't get the certification form for CLE credit prior to coming in, they will be available at the desk after the program. You need to complete those. For questions, at the end of the program, we'll have a few minutes for questions and answers. For those of you in the room, you will have an opportunity to write questions on index cards. And for anybody here or for watching around the country, you can submit questions via the website sli.do, S-L-I.do. The event code is SCR 2019. And we hope you will engage in the conversation. For those of you joining for the first time who may not be familiar with ADL's work, ADL was founded in 1913 with a mission to stop the defamation of the Jewish people and secure justice and fair treatment for all. In order to further our mission and priorities to combat anti-Semitism and fight all forms of hate and discrimination, we regularly file amicus briefs in state and federal courts and the Supreme Court. To protect religious freedom, combat discrimination, protect immigrants and refugees, and safeguard our nation's democratic principles. We filed amicus briefs in several decisions that we will be discussing today, and I will mention those in a little bit. We have what I think will be an exceptionally interesting program today at an unusual and critical moment for the future of our democracy. In just 2 hours, we will take you through this term of transition, deep divisions, surprising alliances, starting with the impact of Justice Kavanaugh's confirmation hearings, and ending, or more like continuing, with the federal government seeking to explore ways to add the citizenship question still to the 2020 census. If anyone can make sense of this term, it's these panelists. So let's get right to the program. You can find more about each of our presenters on our website and in your program, so I'm just going to say a few words about our esteemed panel. Next to me is Erwin Chemerinsky. Erwin is the Dean of UC Berkeley School of Law. Before assuming his post at Berkeley Law, Erwin was the founding dean and distinguished professor of law at the University of California, Irvine School of Law. one of the leading scholars on constitutional law, federal practice, civil rights and civil liberties, and appellate litigation. Erwin is the author of 10 books and more than 200 articles in top law reviews. In January 2017, National Jurist magazine named him the most influential person in legal education in the United States. I will go to his left. We're pleased to be joined this year by Paul Clement, a partner in the Washington, D.C. of Kirkland & Ellis and former Solicitor General of the United States from June 2005 to June 2008. Before his confirmation as Solicitor General, he served as acting Solicitor General for nearly a year and as Principal Deputy Solicitor General for over 3 years. He has argued over 90 cases before the U.S. Supreme Court, including most recently on behalf of North Carolina in the partisan gerrymandering case we'll be discussing today. Paul has actually argued more Supreme Court cases since 2000 than any lawyer in or out of government. So we're so honored to have Paul joining the Supreme Court Review Program team this year. To his left is Dahlia Lithwick, a senior editor at Slate, where she writes the Supreme Court dispatches and jurisprudence columns. She hosts the amazing podcast Amicus, and she's been a guest commentator for the New York Times editorial pages. Her work has appeared in the New Yorker, the Washington Post, Commentary, and more. And finally, Fred Lawrence is the Secretary and CEO of Phi Beta Kappa Society, America's first and most prestigious honor society. He's also a visiting professor at the Georgetown Law Center and the McCourt School of Public Policy at Georgetown University, previously served as president of Brandeis University, my alma mater, dean of the George Washington University Law School, and visiting professor and senior research scholar at Yale Law School. Fred is one of the nation's leading experts on civil rights, free expression, and bias crimes. So let's get to it. Erwin, starting with you, once again, there's been no doubt an unusual term, one that started out, I think, with many in questioning the integrity of the Supreme Court, and one that ended with a lot of confusion. So we'll get to the decisions, but can you help us make sense of what has happened this year? What are the major takeaways?
It's wonderful to be part of this program again, and terrific to be with Melissa and Dahlia and Fred and Paul. It was an unusual term. It began with 8 justices on the court. It began with the very divisive hearings and confirmation of Brett Kavanaugh. Few overviews with regard to the term. First, the court was as divided as ever, but less ideologically split. The Supreme Court decided 67 cases after briefing oral argument. 21 were resolved by a 5-4 margin. That's almost the same as last year, where there were 59 cases decided after briefing oral argument, and 19 were 5-4. But last year, the conservatives were the majority in almost all of the 5-4 cases. In fact, in 14 of the 19 5-4 decisions, the majority was Chief Justice Roberts, Justice Kennedy, Thomas Alito, and Gorsuch. This year was different. This year, the 5 conservative justices, Chief Justice Roberts, and Justice Thomas Alito, Gorsuch, and Kavanaugh, were in the majority in half of the 5-4 decisions. In many of the other half, the liberal justices were in the majority, but when the conservatives go along with them. In fact, there were 4 cases this term, there were 5-4, where Justice Gorsuch joined together with Justice Ginsburg, Breyer, and Kagan to create the majority. Now, I'd be careful about generalizing too much from one term. I'd also be wary of focusing on aggregate numbers. And I'm also careful about generalizing because of my second observation. I think to the greatest extent possible this term, the court was avoiding the most controversial and divisive issues. On Friday, January 11th, the justices met in their private conference to take the remaining cases for this term. They had 8 slots open for their April oral argument calendar. They had an astounding array of cases to choose among. They had a Ninth Circuit case that had affirmed a preliminary injunction against President Trump's rescission of DACA, the Deferred Action of Child Arrivals program. They had a Second Circuit case that upheld the New York law that largely prohibited guns outside the home. That a Seventh Circuit decision that had struck down an Indiana law that imposed great restrictions on abortion. They had a split among the circuits as to whether sexual orientation discrimination in employment is for sex discrimination in employment that violates Title VII. They had a case in terms of whether or not discrimination against a transgender individual, discrimination based on gender identity, violates Title VII. They had 3 cases where federal district courts had enjoined President Trump's ban on transgender individuals serving in the military, and the Trump administration was asking for expedited Supreme Court review. They had a decision in the New Jersey Supreme Court that said local governments cannot give money to churches for historic preservation. Do you know any of those cases the Supreme Court took for the April oral argument calendar? None of them. And I don't think that's coincidence. I think after the bruising Kavanaugh hearings, the justices were trying as much as possible to have a lower profile. In fact, when you think of the two most controversial cases we'll talk about from this past term, I think in each instance, the justices felt they had to take the case. There's the partisan gerrymandering case that Paul will talk about, but they came from 3-judge federal district courts where the Supreme Court is obligated to take and hear the case. There was the Census case, but there the Trump administration told the Supreme Court that forms absolutely had to be printed by June 30th, so the court needed to grant expedited review. Now, the court has taken many of the cases that I alluded to for next term. There's always unintended consequences decisions. I think here the unintended consequence is that the court will be resolving these high-profile cases in the spring of 2020 in the midst of an election season. So I don't think the court's going to succeed in the long term in having a lower profile. A third theme of the term is about stare decisis and precedent. Ultimately, when we get to issues like abortion, affirmative action, gay and lesbian rights, so much will depend on the court's attitude with regard to precedent. There were 4 cases this term where the court asked to explicitly overrule longstanding precedent, but there are several others where that was the underlying issue. The court did overrule longstanding precedent in 2 cases, Franchise Tax Board versus Hyatt, where the court held that states cannot be sued in other state courts, and Nick versus Township of Scott, Pennsylvania, where the court said there's no need to exhaust state remedies before bringing a claim under the Takings Clause into federal court. I argued the former of those 2, Franchise Tax Board versus Hyatt, and I was struck by how many of the questions in oral argument were about the role of stare decisis. At one point, Justice Alito said to me, how would stare decisis be served by affirming the prior case that held that states could be sued in other state courts? And I talked about the reliance there had been on Nevada versus Hall. Justice Breyer then did a 2-minute soliloquy on why precedent matters. And he tacked on at the end, do you agree? I paused for emphasis and said yes. Chief Justice Roberts said, I thought that's what you would say. Justice Alito then said, aren't we better off in terms of public esteem overruling cases that we think are wrong rather than continuing them? And I talked about why precedent matters in the law. Justice Kavanaugh then said he thinks precedent should be overruled when it's egregiously wrong. I said I agree to that adverb, and the prior decision wasn't egregiously wrong. But I don't think the justices were so much focused on the decision Nevada versus Hall from 1979, whether it should be overruled. I think they were really talking to one another about, does precedent matter? The court did overrule the precedent in this case. It was 5-4. Justice Breyer wrote a powerful dissent that concluded, one only has to wonder what other precedents are vulnerable. Final overview with regard to the term is about individual justices. I think we saw that it is the John Roberts Court. He wrote the majority in the 2 most important cases that came down on June 27th. In fact, he wrote the majority opinion in 36% of the 5-4 decisions this term, more than any other justice. We also saw Clarence Thomas stake out a radical position in so many areas of law. In case after case, he called for the overruling of longstanding precedent. In Idaho versus Garza, he said that Gideon versus Wainwright was wrongly decided. That's the case that says that the states have the obligation to provide counsel for those who can't afford them if there's a possible prison sentence. No one ever says Gideon versus Wainwright should be overruled. In McKee versus Cosby, he said New York Times versus Sullivan was wrongly decided. It's the case that limits defamation suits by public officials and is often regarded as the most important free speech case ever. In Flowers versus Mississippi, he said Batson versus Kentucky was wrongly decided. And this is the case that said prosecutors can't exercise peremptory challenges on the basis of race. In a case that we'll talk about, American Legion of Human Association, he said the Establishment Clause of the First Amendment shouldn't apply to state and local governments at all. He has staked out the most radical position at the far right of the Supreme Court. And finally, I think that Justice Kagan had a stronger voice this term than ever before, writing impassioned dissents, such as in the gerrymandering case and the case about property rights. I think the question that we're going to have to see is this term harbinger of what we're likely to see to come, or was it really just an atypical case at the beginning of a new era of the Supreme Court?
To that question, would anybody like to jump in and respond?
I would just add, first of all, thank you for having me back. It's great to be back. It's great to have Paul here. I would add that I think there's an interesting duality that was at play that's just a slight gloss on what Erwin just said, which is it's clear that the court is allergic to unseemliness. And it is allergic to ugliness and rancor, and so we really did see, particularly post-Kavanaugh hearings, a massive circling of the wagons, Justice Sotomayor, Justice Kagan at pains to say, he's wonderful, we're glad he's here. And I think for people who thought that the rancor of those hearings was going to somehow, infiltrate the court, there's no evidence of that whatsoever. They have a vested interest in playing nicely together. I think that in addition to dodging the cases, there was a real effort to remove the court, in some sense, from the hurly-burly of what was happening down the street at the White House, what's happening across the street in the Senate. I think there was a really redoubled effort to say, we are the adults in the room, and that's, I think, some of the improbable splits that Erwin describes are a little bit a function of trying to say, this is not a political institution. But I just want to sort of add a footnote to that, which is it's very interesting how much rancor seeped into individual opinions this year. And some of the discussions that Erwin flicked at, things that Justice Thomas wrote that were quite strong and strident, and I think especially in sort of these kerfuffles of last-minute death penalty stays, where there was a whole bunch of back and forth about whether, quite literally, the other side was cheating or the other side was denying people of their rights, and the level of very personal, polemical attacks on both sides, I thought was quite striking. And I just remember sitting here years ago, and Erwin used to say, Justice Scalia had really kind of opened the gates to that kind of quite personal attacks. Yeah. I think it is now clear, like the horses are out of the barn, and the willingness to impute bad faith to the other side, particularly in the death penalty context, but even, we're going to talk about the Census case, even in the Census case, the willingness to start from the presumption that people are lying and cheating, underneath all the sort of smiley, happy, get-along guys, there was a tremendous amount, I thought, of unprecedented assumption that something is fundamentally broken. And I just want to flag it because I think it, as Erwin says, might be a harbinger of tone to come.
Right. So let's move into some of those decisions right now, and picking up not just on the personal attacks, but the scathing and now famous dissent by Justice Kagan in the partisan gerrymandering case, and one of the two sort of most prominent publicized cases at the end of the term. After the Supreme Court dodged the question last term, now with a different court makeup, the court heard a constitutional challenge to partisan redistricting in this pair of cases out of North Carolina and Maryland. ADL actually joined an amicus brief urging the US Supreme Court to set limits on partisan gerrymandering. Paul, you argued the case to the Supreme Court on behalf of the state of North Carolina. Can you take us through these cases and what the court, sort of finally decided to, where they finally decided to land on this?
Sure, I'd be happy to. And let me first just say I'm delighted to be here and part of such a great group. And so just as the new kid on the block, I really couldn't be happier. I guess it's a little bit daunting to have to start talking about a case where I was arrayed on the opposite side of my hosts, but I'll give it a shot. So, partisan gerrymandering is an issue that I think it is fair to say, and certainly the Chief Justice in his majority opinion said it, is an issue that's as old as the Republic. And I think, here at the Constitution Center, I can't help but make the observation that Patrick Henry actually tried to gerrymander James Madison out of the first Congress. And if he had been more successful at it, the Bill of Rights might have looked very different from the Bill of Rights that emerged from the first Congress, largely via the pen of Congressman Madison. Also Alexander Hamilton, who I think there's a display around here somewhere about Alexander Hamilton. At a couple of years after the Bill of Rights and the Constitution was ratified, and the winds of political change seemed to be on the horizon in New York, tried to get the then Governor John Jay to do a little bit of a gerrymander to help the Federalists in New York. And Governor Jay said that that would really be unbecoming and declined to do it. So I'm not sure there are a lot of constitutional issues where all three authors of the Federalist Papers were kind of directly involved in the underlying enterprise. But partisan gerrymandering really does go back all the way to the beginning of the Republic. I think although the court ultimately divided 5-4 in these cases, one case arising out of North Carolina, one case arising out of Maryland, I do think that probably all 9 justices could agree on at least 2 propositions. One is that partisan gerrymandering is something that is, as Governor Jay would say, unbecoming. It's a problem. It is not something to be applauded. And the second thing that they could agree on is that the Constitution doesn't address it in express terms. And I think from there you have your basic point of departure that really divided the majority of the court and the justices in the dissent, including that quite passionate dissent by Justice Kagan. So from the perspective of the Chief Justice and the 4, roughly speaking, conservative justices, the fact that this is a problem doesn't make it a problem that judges wielding the Constitution are necessarily the right entities to address. And I think in particular, because the Constitution really doesn't address this directly, and the judicial role here is a difficult one, because another thing that I think that all 9 justices would agree, but certainly at least the 5 justices in the majority would certainly agree on, is that a certain degree of partisan gerrymandering is constitutionally tolerable. I mean, and this really flows from the basic constitutional judgment that the basic responsibility for drawing district lines is given to either is primarily given to state legislatures with respect to both congressional elections and to state level elections. And so it's very hard to give a responsibility to state legislatures that at the framing and certainly very, very soon thereafter were organized along partisan lines. It's very hard to give them that responsibility and say, but you shall not take partisan advantage into account at all. And then that creates the dynamic that the judges, if they're going to get in the business of policing partisan gerrymandering, have to have a metric for saying how much partisan gerrymandering is too much. And for the Chief Justice and the judicial conservatives in the majority, I think in an area where they believe that the Constitution doesn't provide a specific yardstick, they are inclined to say that there's no appropriate judicial role. And that's exactly what they did. And the court has been essentially playing at the margins of this issue for 3 decades. They first got involved in a case called Bandemere involving Indiana elections. I think at the time, people could pretty much look at what the Indiana legislature did and said, this is a pretty egregious partisan gerrymandering. And the court in that case came up with a very odd result, which was to say that they thought these claims were justiciable, but no 5 justices could agree on a standard. The court revisited it about a decade and a half later in a case called Veith, arising out of Pennsylvania. And there you had another one of these weird, unsatisfying results where 4 justices said that these claims are completely non-justiciable, so there's no appropriate judicial role. 4 justices said there is a judicial role here. And then Justice Kennedy wrote this opinion that really only Justice Kennedy could have written, that said he kind of agreed with everybody, and that he didn't think that they had yet identified a justiciable standard, but he didn't want to close the door on eventually identifying one. And so the courts were really left kind of trying to figure out whether or not there was a justiciable standard. A number of lower courts in this last cycle have tried to come up with standards and feel like they came up with justiciable standards, but when this issue was squarely teed up for the Supreme Court this term with a 9-justice court, 5 justices said they were not justiciable. That led to Justice Kagan's very passionate dissent. She pointed out to the fact that this is an odd time, in her view, for the Supreme Court to be saying that there's no justiciable standard when lower courts seem to be coalescing around some judicially manageable standards, manageable in her view. But I think what this division shows more than anything else is the fundamental disconnect, really, between the conservative justices on the court and the more liberal justices on the court about what's the proper judicial role when the Constitution doesn't speak specifically to something that everybody can acknowledge is a problem. And I think the conservative instinct is more to say that not everything that's problematic is unconstitutional. And I think the instinct of the justices in the dissent is more that when something is problematic and goes to the very basis of our democratic government, there has to be some judicial role, at least for policing real outlying results. And I think for the dissenters, they thought both the North Carolina map and the Maryland map were outliers. Let me just say one other thing about the case before letting others jump in here, because I obviously, having litigated the case, I suppose, have pretty set views about some of these issues. I will just highlight, though, something that Erwin mentioned, because I think it actually ultimately is a real key to the case and the Chief Justice's approach to the case, and that is that these partisan gerrymandering cases, by a quirk of judicial procedure more than anything else, come to the Supreme Court on its mandatory docket. Very few cases come to the court on a mandatory docket. On most issues, the court can say its piece, even if it's not very clear, let the lower courts mess around with it for a decade and not jump back in until they have something coherent to say again. But in a few areas where they have mandatory jurisdiction, they really have no choice but to take these cases kind of term after term whenever somebody raises the issue and a case goes before a three-judge court in the lower courts and then an immediate direct appeal to the Supreme Court. And although that sounds like very kind of inside baseball, judicial procedure type stuff, I think it may actually ultimately explain why the Chief Justice had such a strong reaction to these cases, which you saw even in the oral argument last term when they dodged the issue on standing grounds. Because I think the prospect of getting involved term after term in cases where everybody would process the winners and losers of the case in partisan terms, and there's really no way to look at these partisan gerrymandering cases. They tend to be Democratic voters against a Republican legislature or vice versa. So it's hard to talk about these cases in nonpartisan terms. It's hard to talk about the winners and losers of these cases without saying that the Democrats won in the Supreme Court today or the Republicans won in the Supreme Court tomorrow. And I think that dynamic, along with the fact that there wasn't some very clear constitutional metric where they could say, well, of course the Democrats lost, but it's not because we like Republicans more than Democrats. It's because the Constitution speaks directly to the issue. I think that dynamic is largely what led the Chief Justice in particular to say this is not a thicket that we want to get into year after year, term after term.
Yeah, Erwin, jump in. You actually wrote that the Supreme Court abdicated its most important role enforcing the U.S. Constitution. So tell us.
I think as you appraise the partisan gerrymandering decision, you need to focus on three questions. First, does partisan gerrymandering violate the Constitution? Second, is a remedy likely without federal judicial involvement? And third, could the court develop a workable standard for when partisan gerrymandering violates the Constitution? In terms of the first question, Paul recites how partisan gerrymandering has gone on since early in American history. But what's changed is, because of sophisticated computer programs and mass data collection, it's possible to engage in partisan gerrymandering with far more precision than ever before. North Carolina is basically a purple state. It went for Obama in 2008, Romney in 2012, Trump in 2016, but always by a 51-49 or 52-48 margin. Republicans and Democrats got about the same number of votes for Congress statewide in 2016. But Republicans set out in a written report to draw a map that would give Republicans control of 10 of 13 seats in Congress in North Carolina, and they succeeded. We all learned, maybe in a civics class, that it's supposed to be voters who choose their elected officials. But partisan gerrymandering is the elected officials choosing their voters. And none of the 9 justices deny the way in which partisan gerrymandering is a threat to democracy. Second, is there likely to be any remedy without federal judicial involvement? This seems a place where the political process isn't going to succeed. Legislators who benefit from partisan gerrymandering, like in North Carolina, aren't about to change the practice and vote themselves out of office. This is especially where we need the courts. Third, could the court develop a workable standard? Is it more difficult in this area than others? The Supreme Court has said that race can't be used as a predominant factor in drawing election districts. Why couldn't that be the test? Or there's a test that says simply measure the party in terms of how the votes they get compared to the number of seats they end up in the legislature. And if there's no explanation, then that's a violation of the Constitution. Or as Justice Kagan said, they drew 3,000 maps in North Carolina and picked the one that would give the greatest advantage to Republicans. Justice Kagan said, use a traditionalist test. Look to what was the purpose, what was the effect, and what's causation. However you frame the test, I can't believe that in this area of constitutional law, compared to all others, no test could be formulated. Now, Paul offers a very compelling case that this is really about judicial process and how conservatives and liberals disagree about it. I want to offer an alternative explanation. At this moment in time, partisan gerrymandering far favors Republicans over Democrats nationwide because Republicans control many more state legislatures than Democrats. And 5 justices appointed by Republican presidents said, we don't want the federal courts to be involved, so partisan gerrymandering will be unchecked by the Constitution. I think that's why Justice Kagan concluded her dissent in a way that at least I've never seen before, saying, sadly, she dissents.
So,
Just
yeah, go ahead.
a quick word. First of all, a formal welcome to Paul. This is Erwin's 20th time doing this program, mine 19th. So to hear the guy who's argued more cases than anybody else before the Supreme Court call himself the new kid on the block, that's sort of the high point of the entire event for me already. I just want to reiterate Erwin's second point, and actually said it in a longer historical context, because I think there's a tendency for this to feel like a very hot button, left-right, red-blue issue. It's a long time ago now, more than half a century, that John Hart Ely wrote his famous book, Democracy and Distrust, about a case for judicial activism, which I think at the time was seen as a pretty moderate or even conservative case for judicial activism in cases in which the political process will not be self-correcting. And he was looking to cases like Baker against Carr, Colgrove against Green, to make that point. So in many ways now, a half century or more later, we're back in the business of asking, is this one that is likely to be self-correcting politically? And I think this was Erwin's second point. I think overwhelmingly the answer is going to be no. And so there's an argument here situating it not just in our current moment, but in a much longer public judicial discussion of judicial activism. There was a strong argument here for the court to weigh in an area that certainly has issues of justiciability because it's such a heavily political issue.
And if I could add one tiny gloss to that, maybe it's obvious, but I think the other thing that to me felt like a kind of cri de coeur in Ginsburg's dissent, Kagan, sorry, dissent, is that there's a through line, and we'll talk about the Census case in a minute. I think that this feeling that public nihilism has to be taken into account, and that for American citizens to feel that their vote doesn't count, particularly at a moment when one wants them to feel that their vote counts, is a little bit a part of the problem. And I think what she worries about, and it's a non-trivial worry, is the sense that voters are going to look at this accretion of cases where the court says, you know, we're not deciding, there's no decision to be taken, that all it does is signal to people that, you know, the process is broken, it's going to get more broken, and there's nothing to be done. And I just think she worries about public confidence in a way that now, in some sense, is dialed up to 12.
Right, so Dahlia, staying with you now for a moment on that theme of fair representation and sort of confidence in that, in our institutions. Let's go to the citizenship question, to the 2020 census. ADL actually also joined a brief in this case, a brief that was joined by over 150 civil rights organizations, refuting the government's attempt to assert that the question was actually necessary to enforce Section 2 of the Voting Rights Act, when in actuality would undermine Section 2 of the Voting Rights Act. At the end of last week, DOJ revealed that it's still searching for new justification for the citizenship question. Reports are circulating about a new legal team. The story seems to be changing by the minute. Dahlia, you actually call this a constitutional reality show so aptly. So help us make sense of the decision and maybe not where we are right now, but try.
I want to start by stipulating when I agreed to do this case, I didn't think it would be unfolding in real time. I thought I could talk about it with some level of, sweeping week ago rearview mirror. I don't know what's happening right at this minute because my phone's been off for 15 minutes. But I'm super interested in what the panelists think is going on. The sort of quick and dirty version is that the Constitution calls for the actual enumeration of the population. Soon after he took office, Commerce Secretary Wilbur Ross started having conversations about wanting to add a citizenship question to the census. There hasn't been such a question on the census since 1950. I think immediately he ran into a couple of problems. One was that the professional staff at the Commerce Department said this will significantly depress minority and non-resident participation in the census, probably a 5% decrease in participation, particularly in light of general anxiety in the immigrant community right now around other issues, and that there are other instruments that can be better at determining what the actual population of citizens are. And obviously the way the census counts the population has massive implications for apportionment of congressional seats and also for disbursement of funds. So it is massively consequential. And Wilbur Ross, I guess, asked, I don't know if this is disputed, but asked several different entities to give him a reason, and the Justice Department, after a little bit of arm twisting, said, yeah, the Voting Rights Act enforcement, they had not actually sought to enforce other Voting Rights Act cases, but they wanted it so that they could better enforce the Voting Rights Act, and that became the stated reason for putting this onto the census. New York and a bunch of immigrants' rights groups sued. There was some quite hair-raising reasons to believe that not everything was truthful in the story being told about the Voting Rights Act. And the claim under the Administrative Procedures Act, so not the equal protection claim, but the claim that simply said that under administrative law, you cannot make changes that are, quote, arbitrary and capricious. There has to be a reason that you change a law, and Judge Jesse Furman in New York, in a pretty copious 272-page opinion, said, under the APA, this is pretextual. It is not about the Voting Rights Act. We're going to table the questions about equal protection. And in the midst of all this, as you probably know, a huge trench of other information that emerged this spring, where there was a Republican voting rights activist who sort of pretty expressly said, hey, this would be a really good way to swing seats to whiter rural districts and take away representation from minority Democratic districts. All that was revealed. It was not relevant per se in the APA portion of the case, but it was certainly in the court's headphones as this was being argued in April at oral argument. I think everybody felt as though there was going to be a 5-4 decision, that it was just fine, and John Roberts surprised everybody by kind of splitting the baby in the last day of the term and voting that yes, under the APA, it was probably okay for the Commerce Department to add the citizenship question to the census, but that it was pretextual, that the reason for doing it was pretextual. His quote was, "We are presented with an explanation for agency action that is incongruent with what the record reveals about the agency's priorities and decision-making process." Incongruent doesn't sound like liar, liar, but it was kind of read that way. And so he voted with the liberals. We can talk about what exactly that remand meant, because I think it was very unclear what he was doing procedurally, but essentially what he said is it goes back to the lower courts, and we all poured ourselves a cocktail and thought the summer had begun. The 4 conservatives on the court, I think, would have been fine with the question going on the census regardless. The liberals, I think, would have kicked it away and said it was arbitrary and capricious no matter what. So Roberts really does, in this sense, become the reality show star at the center of the court, who's giving a little bit to both sides, but nobody knows quite what's happening. And that brings us to the government had said throughout the case that they had a June 30th deadline to get it to the printers. That's the reason they leapfrogged this case so quickly to the Supreme Court. And so it seemed as though it had to be over because they were going to miss the deadline. Wilbur Ross said at the beginning of last week, I'm done here. The Justice Department made representations suggesting they were done here. Donald Trump tweeted, fake news, we're back on, we're looking for a path. Judge Hazel, who's the judge in the Maryland case, summoned them all in a teleconference and said, I don't know, I'm reading the tweets, somebody tell me what's going on. The Justice Department lawyers said they didn't quite know what was going on. It was awkward. And then, as Melissa said yesterday, those lawyers sought to withdraw from the case and be replaced by another team of lawyers. So the second question, this equal protection question about whether there was a racial basis for doing this, that is still obviously percolating on the side here. But what is really happening as we're speaking is that the administration is talking about possibly doing this by way of an executive order. There were a bunch of opinions this weekend in the various newspapers saying this could be done by executive order and just circumvent the judicial process. And then there's conversations about going back and doing a redo, finding a better rationale at the Commerce Department. And so the last I heard, the Attorney General Barr said, we're going to redo a thing, stay tuned, and here we are.
Right. And if they redo a thing,
Pardon me?
If they redo a thing in the judicial system, how likely do you all think it is that Roberts would uphold the question under a new rationale?
You know, the euphemisms have been flying in this case, and one's inclined to make light of it, but in fact, it's extraordinary.
Yeah.
That when Dahlia says incongruent is sort of sounds like liar, liar. That's the Chief Justice of the United States Supreme Court essentially telling the administration that he doesn't believe the argument that's being made, and I think that belief is not improved by the events that have taken place since then. If you haven't read the transcript of that phone judicial conference, which was the day before the 4th of July, I strongly encourage you to get it. It's online. And reading between the lines, first of all, having been a government lawyer, having been an assistant U.S. attorney, I felt the sort of exquisite uncomfortableness of this lifer at the Civil Division, who's been there for 16 years, I think. And he starts by saying, I have never misrepresented to this court, and the court says, you have been nothing but honest before this court. And if you just read those lines, you think, well, that's sort of the nice patter between a lawyer and a judge. No, everybody understands what's the subtext here. And then if you want the little punchline, and it lands so quietly that you got to be listening carefully to hear it, it's when the judge says, Friday at 2 o'clock, one of two things is going to happen. I'm going to get an agreement that this question's not going to be on, or we're going to have a scheduling order to go forward on the equal protection issue. And the lawyer for the government says, can we have until Monday? And the court says no. And says, I think I've been patient enough. And I think, again, just reading those lines, and particularly for non-lawyers, that sounds like the way people talk. I think the subtext here is extraordinary, that there is a lack of trust in the whole process, which is then further compounded by changing lawyers at the last moment. So when all of that adds up to Chief Justice Roberts, let's just say I don't think the government's case for believing the justification has been improved in the last week.
Chief Justice Roberts says the justification can't be a pretext. But wouldn't inventing a new justification now be the very essence of a pretext? And I want to highlight something Dahlia says. The government repeatedly said to the courts that the forms had to begin printed by June 30th. Whatever litigation is going on, it's going to take a long time. What of that deadline that the government continually emphasized to the Supreme Court and the lower courts?
I want to move, oh, sure.
Okay, just one other thing that I should have said and didn't. in the intervening whatever days of mayhem, the other thing that changed in addition to the deadline was, I think the Washington Post has clocked 10 different rationales that have now been offered. But one of the rationales that President Trump offered last Friday, he said in a news interview, we need it for Congress and for districting. We need to know how many people there are and how many are citizens or non-citizens. That's something that was expressly disavowed in the litigation of this case. So in addition to the shifting deadlines, I think we have a problem where the president is creeping up on embracing. If Erwin says you need to embrace a better pretext, don't embrace the pretext you've expressly rejected. So I think that's the other problem, and I think there's some reason to feel that some of those attorneys who, for whatever reason, have been removed for the case, were not only making misrepresentations at this point against their will about the drop-dead deadline, but also about what do you do when the president is now embracing that we're doing this to figure out who is not a citizen for immigration purposes.
Right. And I want to come back to that when we discuss sort of immigration and the Supreme Court this year, because of the impact on the immigrant communities, regardless of where it goes next. Fred, before that, I want to turn to you for, I'd say, sort of less publicized decisions, at least at the end, right now. But I don't, no less impactful, perhaps. And that went to the core of just sort of how broken our criminal justice system is, sort of those criminal law decisions, including racial discrimination in jury selection, religious liberty rights at execution. Very public, deep rifts were exposed, as Dahlia mentioned earlier. So let's turn to Flowers versus Mississippi, Madison versus Alabama, and those pair of religious liberty rights at execution cases, Dunn versus Ray and Murphy versus Collier. Can you take us through the impact of those?
But before those, just very, very briefly, it was an interesting case. It's not really one of our standard cases that we would do in the ADL docket, but it exposed an interesting difference between Justices Kavanaugh and Gorsuch, who I think there's a temptation, particularly in the public discussion, to say those are the two Trump justices, those are two conservative justices, and on one level of abstraction, that's correct. But there are real differences between those two, and you saw them in a very interesting case that may have missed the attention of most people who were not real federal criminal law junkies. But the case called the United States against Davis, in which the court, by a 5-4 vote with Justice Gorsuch writing the majority opinion and Justice Kavanaugh in dissent, strike down a provision of the federal criminal law that provides for certain kinds of penalties where you have a firearm used in a crime of violence. And the question is about whether crime of violence is a too vague a term, and therefore the law must be struck down. That's what the majority says, the 4 liberal justices joined by Justice Gorsuch. Or is it one that can sufficiently be given meaning by the court, which is what the 4 dissenters and Justice Kavanaugh say. It's not just the words of the opinion, it's the music. The opinion by Justice Gorsuch has got a strong libertarian trend. If a law is vague, then the court must strike it down. Then it is no law at all. It is void. And then he works through that. And that is a libertarian trend that says that it's the obligation of Congress to pass laws that are clear and that people can understand how to amend their conduct accordingly. Justice Kavanaugh begins his opinion very differently and talks about the levels of crime and the levels of crime involving firearms and what that law was about. So it's a very different version of conservatism, hardly a libertarian, sort of a more traditional conservative position. I just give that as an example of 2 justices who we think of as being the same. They are most certainly not, even if they wind up in the same side of many other of the cases that we'll do. Flowers against Mississippi is a case that actually Erwin alluded to earlier as one of the cases where Justice Thomas, in a dissent, takes a fairly radical position where he suggests that Batson against Kentucky, a 1986 precedent that now stands for what one would think is the fairly well-established rule that racial discrimination in the selection of juries taints a trial and therefore is unconstitutional and permissible. That Thomas actually calls in a dissent to the questions Batson against Kentucky and says it should be overruled. Justice Gorsuch joined him in his dissent except for that part. So it's a 7-2 decision in Flowers. Flowers involves the question of whether Batson allows the court to the district court to do a search throughout the trial process and looking at whether or not there was racial discrimination. Flowers itself is a lengthy set of cases. Let me summarize it by saying there were 6 trials. Flowers was tried 6 times for murder of 4 employees of a furniture store. Flowers is black. 3 of his victims were white. In all 6 of those trials, the state used preemptive strikes to strike most, and in some cases all, of the black jurors. His first 2 convictions were overturned because of prosecutorial misconduct. The third, the state used all of its preemptory strikes against the black prospective jurors, and Flowers received the death penalty. At that point, the Mississippi Supreme Court reversed, concluding that Batson had been violated. 4th and 5th, if you're keeping track at home, 4th and 5th trials lead to mistrials. This is the 6th trial, finally, where the court exercised 6 strikes but allowed 1 black juror to be seated. The trial court concluded that the state had offered race-neutral reasons for each of the 5 preemptory strikes against African-American prospective jurors. The question then raised in Flowers is the extent to which all of the history of this prosecutor and all of the history of this prosecution can be brought to bear in determining whether or not there was racial discrimination. And the court, by a vote of 7-2, says that under these circumstances, the trial court misread the Batson rule, which is to say, first, is there discrimination per se? If so, a burden shifts to justify those preemptive strikes, and then the question of whether that's pretextual or not. In evaluating whether or not the justifications are pretextual, the court should have looked back at the entire course of Flowers' prosecution. And so Batson is applied in this case, and by a vote of 7-2, the court reverses and remands for what I suppose will be yet a 7th case, unless they decide that Brother Flowers has had enough for one lifetime. Madison against Alabama is a death penalty case before Justice Kavanaugh had joined the court, so it's a 8-justice bench that decides by 5-3. The 5 made up here of the 4 liberal justices and the Chief Justice, in an opinion by Justice Kagan, on the question dealing with mental capacity of a defendant with respect to the imposition of the death penalty, a series of fairly complex rules about whether someone who has no longer can even remember the crime could be subject to the death penalty. Justice Kagan tries to bring some clarity to an area that had been somewhat confusing and says the question here is whether or not the defendant can understand why he is being executed. If he cannot understand why he is being executed, then in that sense, the death penalty does not apply because of his mental incapacity. So technically, even if he does not remember having committed the crime because of mental disabilities that have happened since the crime, since the trial, but if he can understand and appreciate the reason he's being executed, then the death penalty will be appropriate, will be constitutional. In some ways, what's most significant in Madison is the flavor of what comes out of the dissent. It's Justices Alito, Thomas, and Gorsuch, an opinion by Justice Alito, where you have a procedural thread in these cases that's going to come through in the other 2 short cases that we'll talk about in the death penalty. He says that the claim by Madison makes a mockery of our rules. That's a quote. Makes a mockery of our rules because Madison shifted the argument from whether he remembered committing the crime to appreciating the reasons for the execution, and that obviously turns out to be the grounds on which Justice Kagan is willing to decide the case. Well, that make a mockery of the rules where the death penalty is involved certainly raises some questions as to whether or not it's a mockery to continue to raise issues that clarify when or not the most severe penalty that we can impose is appropriate. It brings to mind, for some of us, the words of Justice Brennan in a slightly different but related context in his dissent in McCleskey against Kemp, when he said it's as if the majority is afraid of too much justice. And one fears the dissenters are concerned of too much consideration of too many different kinds of claims in the death penalty, and perhaps the possibility of too much justice. In this case, it was a 5-3 vote. Justice Kagan, the Chief Justice, and the other liberals, but the dissent certainly draws one's attention. The two other cases, just briefly, and again, more because it reveals some of the flavor and the splits on these procedural issues going on behind the scenes on the court and the death penalty issue. Dunn against Ray is February of 2019. The court vacated a stay of execution of a death row inmate who argued that he had a right to have a Muslim imam present in the death chamber. There was a 5-4 majority for vacating the execution, the stay of execution, because they said he waited too long to object. He had sought the emergency stay on the 28th of January. The execution date was scheduled on February 7th. Justice Kagan, and again, Erwin talked about Justice Kagan finding her voice in some way in this court. And you see this here in this fairly narrow context of vacating a stay of execution. But she says that there are bona fide establishment clause grounds here that should have been considered. Alabama law allows for a Christian inmate to have a Christian cleric in the death chamber, but not others. So she argued that the 11th Circuit should have been allowed to review this case in full rather than rushing to, and these are her words, allow the state to meet its preferred execution date. And I think there's a thud with which those words land. It reminds me of something that my mentor, the late Charles Black, talked about in the Rosenberg case, where the last stays are not granted by the Supreme Court, and Black, in a Texas drawl I will not attempt to imitate, says they were in such a terrible rush to put those people to death. And so there's a flavor of that, I think, in Kagan's dissent, that we should not be in such a terrible rush to let the state meet its preferred execution date. But then just a month later, Murphy against Collier, that's in March, the court did grant a stay of execution unless the state permitted Murphy's Buddhist spiritual advisor to accompany him into the execution chamber. Justices Thomas and Gorsuch would have denied the application for that stay. Justice Kavanaugh concurred in the grant of the application for the stay, saying, these are his words, state may not allow a Christian or Muslim inmate, but not Buddhist inmates, to have religious advisors of their religion in the execution room. Now, move forward 2 months after the execution is going to go forward in 2019. Justice Alito writes a separate opinion, a blistering opinion, in which he goes back to that stay of execution back in March. I mean, in some ways, it seems almost unnecessary, but again, it's that strong language about violating our rules, and our rules have to be able to apply, which prompts, and I'll end where I began, prompts Justice Kavanaugh, joined by Chief Justice Roberts, to write separately in May defending the grant of the stay and distinguishing the case from the earlier case. I have to tell you, the distinction is one of those that's a pretty hard one to draw. So I don't give you the Kavanaugh and Roberts opinion for the merits of it. I give it for the flavor of that back conversation, and that I think we're going to watch this tension line continue to draw as to whether the court will allow the risk of too much justice or tamp down on too much justice.
So I want to keep us moving, but on that point, I'm moving to another religious freedom sort of issue on a case that exposed so many divisions among the justices, it was hard to keep track. So Erwin, American Legion versus American Humanist Association, the court considered the state-sponsored 40-foot Latin cross, that dominates the Veterans Memorial in Bladensburg. ADL joined partners on an amicus brief in this case that discussed the power of symbols, particularly ones like the Latin cross and what message it conveys, but the majority didn't agree. So Erwin, can you explain?
In 1920, a 40-foot cross was put up in Prince George County, and it was a memorial to World War I war dead. The issue before the Supreme Court is whether that 40-foot cross that now sits on public property at a busy intersection violates the Establishment Clause. The Supreme Court ruled 7-2 that it doesn't violate the Establishment Clause. Justice Alito wrote for the majority, Justice Ginsburg wrote the dissent, but there were 7 opinions altogether. I think in order to appraise this case, you need to put it in some context. For the last 30 years, the justices have been split among 3 different views as to when the government violates the Establishment Clause. The conservative justices have taken the position that the government violates the Establishment Clause only if it coerces religious participation or in giving aid discriminates among religions. The liberal justices believe that there should be a wall that separates church and state, a phrase that comes from Thomas Jefferson, and they believe that religious symbols don't belong on government property. And then there's a middle position. Justice O'Connor first articulated and said, there can't be religious symbols on government property if they be seen as an endorsement of religion from the perspective of the reasonable observer. The last major Supreme Court cases about religious symbols on government property before this case were two decided in 2005 about Ten Commandments displays. One was Van Orden versus Perry. It involves a 6-foot-high, 3-foot-wide Ten Commandments monument that sits at the corner of the Texas State Capitol in the Texas Supreme Court. Paul and I argued that case on opposite sides. I was representing the challenger, Thomas Van Orden. As I prepared my briefs, I knew there were 4 justices whose votes I wasn't going to get. Chief Justice Rehnquist, Justice Scalia, Kennedy, and Thomas. They take that former position and believe that the government only violates the Establishment Clause if it coerces religious participation. No religious symbol will be unconstitutional for them. I thought there were 3 justices' votes I was sure to get unless I really screwed up, and that was going to be Justices Stevens, Souter, and Ginsburg, because they believe religious symbols don't belong on government property. I thought the case was going to come down to Justice O'Connor and Breyer, who believed that there can't be symbols that endorse religion. I mistakenly thought it would come down to Justice O'Connor. My brief was a shameless attempt to pander to Justice O'Connor. If I could have, I would have put Sandra O'Connor's picture on the front of my brief. The week before oral argument, a reporter called me and said, "You cite to Justice O'Connor 23 times in your brief." I said, "So?" Well, I got Justice O'Connor's vote, but lost 5-4 with Justice Breyer concurring in the judgment. He stressed that the monument had been there since 1961 and no one had complained, and to Thomas Van Orden, he said there's many other monuments in the Texas State Capitol grounds. The same day, the court decided McCreary County versus ACLU. It involved a county in Kentucky that required 10 Commandments displays in county buildings. The Supreme Court 5-4 found that unconstitutional, with Justice Breyer joining the liberal justices. Well, I and everyone wondered what was the difference between these 2 cases. And the only thing I could think of is what Justice Breyer was saying is, as to religious displays that have been there a long time, leave them alone, but don't put up any new ones. Well, I think we saw that in the way the court wrote the opinion in American Legion versus American Humanist Association. So Justice Alito wrote to the court, and part of it was a majority opinion and part a plurality opinion, but he stressed several things. He said a cross is a Christian religious symbol, but has other uses as well. He says it's a symbol for the war dead, it's used by the Red Cross. He says Johnson & Johnson uses it. He said the test with regard to the Establishment Clause articulated in Lemon versus Kurtzman in 1971 doesn't work well for religious symbols on government property. And he said to take down a religious symbol that's long been present would be perceived as hostility to religion. Justice Ginsburg wrote in impassioned dissent. She said a cross is a Christian religious symbol. She said it's not a universal symbol for war dead. She said if you walk through Jewish cemeteries, even for those who died in the war, you don't see a cross on their headstone. Now, I think to appraise the case, you have to look at the other opinions that were written. And I'm not going to talk about all the 5 other opinions, but some to focus on. Justice Thomas, in his opinion, said that state and local governments never can violate the Establishment Clause. He believes the court was wrong in applying it to state and local governments. If a state wants to declare an official state religion or do anything it wants to advance religion, it can do so. Justice Breyer said, we're not overruling the Lemon versus Kurtzman test. We're just saying here with regard to religious symbols doesn't apply, and every case has to be taken in its factual context. Justice Kavanaugh wrote and said, yes, we are overruling the Lemon test, and that's a good thing. The Lemon test unduly limits what the government can do with regard to religion. Justice Gorsuch said, no one's really injured by religious symbols on government property, so no one should have standing to challenge them. Where I put all of this together is, I think there are now 5 votes on the Roberts Court to take the conservative position that the government violates the Establishment Clause only if it coerces religious participation or in giving aid discriminates among religions. From this perspective, no religious symbol on government property is ever going to be unconstitutional. From this perspective, very little will violate the Establishment Clause. From this perspective, there are probably 5 votes to overrule the Lemon Test in the future. It just didn't happen here. This case, in terms of what it actually decided, is very disturbing, but it didn't change the law in a major way.
If I could just make 2 complementary observations about this. I mean, one, as I would say, I think Erwin was right to start in talking about the Van Orden case and the Ten Commandments monument on the state capitol grounds, because I do think if you start with the idea that it's okay to have a Ten Commandment display on the state capitol grounds, right at the heart of the government, the idea that a cross that's been on an intersection pretty far removed from city government, the seat of any kind of government, it's public property, but it is, I've seen it, it's kind of removed and kind of off at one side. The idea that that memorial that has stood since the tail end of World War I is going to be something that the court is going to want to tear down, I think it's just, I think it was a bad litigation strategy to try to take that on. I mean, I'm sure there were sincere beliefs, and I've had plenty of clients that have taken positions that they sincerely believe in that probably aren't going to get 5 votes in the Supreme Court. So I understand that these things happen. But I do think to contextualize how important this decision is, I would say that really the result here probably follows a fortiori from the Van Orden case. And in particular, I think Justice Breyer's vote was really predicted by what he did in that case. So then I think, as Erwin says, the interesting thing about this case is less the result, which I think was probably one of the more readily predictable results of any Supreme Court case this term. Once they granted the case with the Fourth Circuit underlying order saying that the cross essentially should be taken down, I think it was pretty clear what the result in the case would be. So then it really is an interesting sort of indication of where the court's going to go. I agree with Erwin with one possible caveat, which is I do wonder whether the court is going to actually feel the need to overrule Lemon v. Kurtzman. I mean, because I do think you see from the various cases that the court's had wrestling with issues of stare decisis, that at least the Chief Justice really doesn't want to overrule any more precedents than he needs to. And there's certain cases that just, they're a binary result. There's no getting around it. So either you can sue another state in one of the courts of its sister state, or you can't. And it's either one way or the other, and you really can't get to a contrary result without overturning a decision. I'm not sure there's anywhere that the 5 conservative justices want to go in the religious liberty or Establishment Clause area that will necessitate them ever actually overruling Lemon v. Kurtzman.
Paul, I want to move us to the latest or an additional public confrontation over separation of powers quickly, although we could spend a long time talking about it. The news in Washington in February, if everyone remembers taking us back there, was consumed by the president's declaration of a national emergency, deciding to use executive power to fund a border wall. We're going to talk more specifically about immigration in just a few minutes, but I'm wondering if you can just take us very quickly through some of the legal and constitutional issues at play, particularly since there are some cases moving in the lower courts, including Sierra versus Trump in California, where additional construction sites of the border wall were blocked. So what do we know about how the Supreme Court sees such executive authority, and what are your senses?
Sure, so I'm going to talk about this kind of border wall, declaration of emergency, reallocation of funds, and then maybe I'll use it to just make a couple of quick observations of how you can, this is kind of related to the Census case in a couple of ways, I think. So one of the things that really dominated Washington was this 35-day government shutdown. And the whole reason that the government shut down was over whether or not Congress would appropriate the funds to fund a sort of full-blown wall on our southern border. And in the final analysis, after 35 days of being at loggerheads, something of a compromise was reached. There was some money that was appropriated for the purposes, but not nearly the amount that the president wanted. In sort of rough terms, he wanted about $5 billion, and he got about $1 billion for the wall. So in the immediate wake of the resolution of that crisis and the refunding of the government, the president then essentially declared a national emergency at the southern border and used that as a basis for reallocating funds from what they had been appropriated to be used for to the border wall. And there was provisions in the Appropriations Act itself and other provisions of law that limit the ability to reprogram or reallocate appropriated funds in that matter. And at least as a statutory matter, some of the restrictions require the new use of the funds to be unanticipated and that it not be something where the funds were sought and denied by the Congress. So as a statutory matter, those would seem like two not particularly low hurdles, given that you have a dynamic where the president expressly sought these funds, and only after not getting the funds did he make the reallocation. And so the real idea from the statutory language anyways, I think, is that you're really only supposed to sort of reprogram funds in a situation where after the appropriations law has passed, there's now some, call it a new war or something, or a new need for funds that was really unanticipated beforehand. So not surprisingly, when the president did this, immediate challenges were brought. Not surprisingly, I suppose, some of those challenges were brought within the Ninth Circuit, which if I were seeking to sue the president right now, that's probably one of the places I'd think about venuing my case, because there have been a number of these cases that filed in the Ninth Circuit that have gotten relatively quick preliminary injunctions, temporary restraining orders on the government's action. That was the case in this instance. The issues in the case as it works its way throughout the system, I think will be not just about the statutory issue, which I think is a pretty tough one for the government, but I think some of the issues that may ultimately make their way to the Supreme Court and be more of a focus of attention are, what are the circumstances in which somebody can sue to vindicate their rights? Does it matter whether the underlying claim here is a constitutional claim? Does it matter whether it's a statutory claim? And I think it's very likely, since the Ninth Circuit has affirmed essentially a stay of the reallocations of the fund, that this is an issue that will find its way to the Supreme Court. So when it does, I think you're going to see the Chief Justice in particular probably have the same dilemma that he had in the Census case. And I think in some respects the government lawyers are going to have a similar dynamic at issue. So starting with the Chief Justice, I mean, this is a justice who I think probably believes as firmly in his executive power as any member of the current court. I mean, there are some things where I think you can think of the Chief Justice as a matter of doctrine being a little bit more in the middle, but I don't think that's the case when it comes to executive power. I think Chief Justice Roberts is the same person who, as a relatively young government lawyer, was writing memos in the White House counsel's office and in the Justice Department that were taking very strong views about the authority of the president. So on the one hand, I think you're talking about a justice focusing on the Chief Justice who is going to be inclined to want to favor the ability of the executive to take action, certainly probably will not want to second guess, for example, the veracity of whether or not there really was a national emergency and the like. But on the other hand, the Chief Justice is also somebody who is both very concerned about the integrity and institutional role of the court, but was particularly offended when the president started talking about Obama judges and Trump judges and Republican judges and Democratic judges. And he's also somebody who, I think as a general matter, believes in kind of, turning square corners, crossing T's, dotting I's. And so I think the dilemma that he faced in the Census case was, how do I sort of affirm the long-run authority of the presidency while perhaps taking some effort to cut back on what this particular president did in this particular instance? And I think that kind of explains the compromise he reached in the Census case. And I think that same dynamic will be at play here. And then I think from the perspective of the Justice Department lawyers, and here having spent 7+ years of my life as a Justice Department lawyer, maybe I have a particular well of sympathy for the difficulties that you can have, even under the best of circumstances, of representing a government where the politically accountable president is kind of ultimately the one that gets to dictate the policies and the litigation positions of the government, but there are all sorts of institutional buffers that are developed to allow the Justice Department to be able to look out for the long-term interests of the United States government and make representations to courts in the way that judges will never second-guess what the government is representing. And in a case like this, I mean, when you put facts into the litigation that are as tough as kind of changing gears immediately from not getting what you want in the legislation and then immediately changing gears and declaring the emergency and immediately reallocating the authority, the funds. Those are very difficult situations, I think, for the government lawyers. They are in a really tricky position. So I think, in a weird way, I think you'll almost see a little bit of a replay of the Census case when this case comes up to the Supreme Court. And you may end up, with some result that is kind of similar in the sense of being a relatively narrow holding, but one that still says that in this particular instance, something about the facts of this case made this move just a little too quick in order to sustain.
Right, right. Fred, on immigration now, building from that, because of the impact on immigration, let's move to the court's treatment then of immigrants and asylum seekers. We hear constantly about the continuous attacks from the federal government looking for these different ways to maneuver, attacks on immigrants and asylum seekers. Last year, the Supreme Court limited the rights of immigrants to bond hearings in Jennings versus Rodriguez, and this term, the court endorsed a strict interpretation of a mandatory detention statute. Can you take us through that decision?
Well, there's an awful lot happening in the immigration area,
Yes.
and as Dahlia said earlier, having not had my phone for the last hour and a half, it's hard to know if anything's happened in the last hour and a half. But let me first take us way back and then
Sure.
quickly up to speed. A lot of what's been happening is actually in the context of the settlement of the Flores class action suit, which takes us way back. Flores was actually brought in 1985. And the settlement itself, after years of litigation, including one trip up to the Supreme Court, is 1997. So that itself is still quite some time ago. And without going through all the details of the Flores settlement, let me just tick off several of the major pieces of it that I think have a currency now that they didn't even a couple of years ago. One is that the government must release children from immigration custody without unnecessary delay. Second is that for children for whom placement may not be found, the least restrictive setting appropriate to their age and any special needs must be used. And finally, the government must implement standards regarding care and treatment of children in immigration detention. Coming closer to our time before the Trump administration. So in fairness, 2015, 2016, these issues were still very much in play. The Central District of California, affirmed by the Ninth Circuit, these are all Ninth Circuit cases for some of the same reasons that Paul was alluding to, held that the Flores settlement applies to children accompanied by parents, not just unaccompanied children. So again, that's got a strong resonance to where we are today. Now moving up more recently, in 2017, Central District of California found that the government was failing to comply with its obligations under the Flores settlements in terms of length of custody, in terms of inadequate food, clean drinking water, unsanitary conditions. The judge required soap, toothbrushes, and showers, as we've been hearing about very recently. And this leads to the Ninth Circuit argument last month, in June of 2019, with the Department of Justice asking the Ninth Circuit to reverse those findings. And most of you will recall the rather uncomfortable argument about whether or not such things as toothpaste and soap would be required of the government. So that's pending before the Ninth Circuit. July of 2018, so a year ago right now, a district court denied the government's request to modify the Flores agreement. But to put this in just stepping outside of the judiciary for just a second, and this is a little inside Washington talk, I understand, but there is a notice of proposed rulemaking, NPRM, for those of us within the Beltway, that has been published that would amend, this is from the Department of Health and Human Services and Homeland Security, joint proposed rulemaking that would amend regulations relating to the apprehension, processing, care, custody, and release of undocumented juveniles. The significance of a rulemaking here is that everyone involved in Flores agrees that once there is actual rulemaking implementing this, that the Flory settlement would disappear, because then it would be a matter of federal regulations. Though the final rule has not yet been published. So this is an ongoing issue, but one to watch that, as I say, feels like inside baseball, but actually is precisely relevant to these issues. A couple of specific areas: the asylum seeker cases, the remain in Mexico case, as it's often known, officially the migrant protection protocols. The Department of Homeland Security policy now keeps some asylum seekers in Mexico for the duration of their immigration court proceedings. Initially, that was rolled out in San Ysidro in this past January. The Northern District of California blocked that policy in April, but a panel of the Ninth Circuit stayed the injunction in May. So that too is an active question of whether or not the government can require asylum seekers to remain on the Mexico side of the border while their proceedings are being heard. A couple of cases involving, if you will, courthouse arrest cases. In Ryan against ICE. This is not up in the Supreme Court, but this is a case where two Massachusetts district attorney's offices filed suit in the District of Massachusetts against ICE over courthouse arrests of undocumented people in April of 2019, and the district court granted a preliminary injunction prohibiting ICE agents from making arrests in and around Massachusetts courthouses. And in Lynn against Nielsen, the district court in Maryland this past May, just 2 months ago, decided that ICE agents had acted unlawfully when detaining a Chinese national who was arrested while meeting with immigration authorities to apply for a deportation waiver. The one case in the court to mention, Nielsen against Priap, 5-4 opinion with the majority, Justice Alito, holding that step back. The litigation involves Section 1226. Without going into all the technicalities, the real issue here is that the statute says that an immigrant shall be taken into custody if they have committed a deportable offense when the alien is released after serving a criminal sentence. The cases involved aliens who had been released 5 to 11 years earlier. So it all turned on that language of when the alien is released. Justice Breyer, in his dissent, said when the alien is released means when the alien is released. And so 5 to 10 years later is too late. That authority of 1226 doesn't apply. Justice Alito, for the majority in that 5-4 case, said 1226 actually does give ICE authority to detain at any time rather than allow them not to be in custody while awaiting deportation. It's worth looking at some of the other concurrences in that case to, again, give the flavor. Justices Thomas and Gorsuch concurred in part and concurred in the judgment. They would limit judicial review here, and unlike the district courts, and they said it was unlikely that the district courts actually had Article III jurisdiction to certify these cases as class actions. Finally, perhaps because it brings us right up to date, is the DACA cases. As Erwin said, the court specifically did not take that up this year, and now it is on the docket for next year. DACA, of course, is the Deferred Action for Childhood Arrivals program that affects nearly 800,000 people today, brought to the States as children. The administration tried to end DACA in 2017, saying it was end run around Congress, and in September of 2017 actually ordered the program be terminated, but delayed the effective date until March of 2018. The Ninth Circuit in November said that the administration's effort to end the program did not provide adequate legal rationale. So that flavor we've been talking about in a number of cases now about testing what the actual legal rationale was. And the Fourth Circuit, this last May, issued a similar ruling. The court, as Erwin suggested, had several go-rounds, actually, to think about this. This one lived longer on the consideration docket than most cases ever do, but having deferred consideration right throughout the year, a week ago, last Friday, on the last day of the term, or actually the day after the end of the term, the court agreed to hear the Ninth Circuit case plus 2 district court cases, which have not yet been to the appellate court level. And so when we meet here next year, I'm sure one of the things we'll be talking about is what the Supreme Court did with DACA.
Right. So let's talk about what we will looking ahead, DACA, the National Emergency Declaration we spoke about. Dahlia, I want to come back to you for a few brief moments on what we can expect from cases next term and in the lower courts. The beginning of the year, for example, the Supreme Court allowed the president's transgender military ban to go into effect, taking no stance on the legality of the ban, but no doubt a blow to the LGBTQ community. And towards the end of the term, the court has decided to take up the question whether Title VII protects against LGBTQ discrimination. And many of us are also on high alert about an anticipated petition to the Supreme Court from a government-funded foster agency here in Philadelphia, seeking an exemption from local anti-discrimination policies because of religious exemptions. So focusing on LGBTQ cases for a moment, what can we expect?
Yeah, and I'll go fast because we want to take questions, and
Yep.
I should just note that we haven't even talked about the Affordable Care Act case, which is, happening.
So there's that.
Happening, and also the law of Mueller, and all the efforts to have oversight. So there's really a lot. But I'll go quickly through these LGBTQ and reproductive rights cases, and then you'll ask those questions in the question time. Okay, so the transgender ban, in 2016, President Obama lifted the ban on transgender soldiers serving in the military after an incredibly extensive RAND study that found that there were not massive costs incurred, there was no huge impact on readiness or morale. It was, I think, seen as a real high water mark for transgender rights in America. 1 year later, in a series of tweets, Donald Trump said there would no longer be such a policy, and I think took some of his own advisors yet again off guard. They formalized the ban a month later. There were some exceptions, but largely that was meant to go into place. There were 4 federal courts who subsequently enjoined that 2017 rescission of the gender, allowing transgender soldiers to serve. And again, this is becoming a theme, but one of the main reasons that courts were willing to enjoin it is that they said it was, quote, not a considered military judgment, that this was just sort of done in a fashion that didn't seem to reflect great consideration. In March 2018, the administration revoked the 2017 policy, and they put in a new one that was based on a new 44-page report, and essentially saying that they would exclude those who were diagnosed with gender dysphoria. And there was a whole long conversation to be had about whether that's the adequate marker. That was yet again enjoined, and then, as Melissa says, in January, the Supreme Court, by a 5-4 margin, lifted 2 of those injunctions, allowing the Pentagon to implement the ban while it goes through litigation. They did not allow it to leapfrog to the Supreme Court the way the Census case did, so that litigation is pending. In mid-June, the Ninth Circuit vacated the lower court injunction in Karnosky, which is one of the cases. They said that the judge had improperly applied strict scrutiny. She needed to apply intermediate scrutiny, they said, and the question really will become whether this is still invidious discrimination against transgender soldiers, and it will just be forced to probe these findings that the Trump administration came up with that suggested that morale and troop readiness are implicated by having trans soldiers serve. The other cases that Melissa alluded to are these questions about Title VII, and there are 2 pending cases that next term, Bostock versus Clayton County, Georgia, Altitude Express versus Zarda, and they're basically a pair of cases that will determine whether federal employment discrimination laws under Title VII of the Civil Rights Act of 1964, which bars discrimination on the basis of sex, can be invoked to protect against employees who were fired, they say, for being gay. Altitude Express was a skydiving company. An instructor, Donald Zarda, was fired in 2010, and he claimed it was because he played in a gay softball league. The trial court tossed his claims. They said Title VII doesn't apply to discrimination on the basis of sexual orientation. The Second Circuit reversed. Bostock was a CASA worker in Georgia, fired in 2013, again claiming that it was because of sexual preference. The question the court is going to have to engage with, and the circuit's courts are split on this, is this question of whether Title VII contemplated that discrimination against gay and lesbian workers when they said that you cannot discriminate on the basis of sex. There's a third case, by the way, that involves a transgender woman who was fired from a Michigan funeral home that is also in that bucket of cases. Fulton versus Philadelphia is the case Melissa just described. That just simply is Catholic Social Services sued Philadelphia over a policy that would stop them, forced them, in their view, to place children in foster care regardless of their religious objection to placing children in homes of same-sex couples. So this becomes another version of the cake baker's case, these religious dissenters who feel that the civil rights and accommodation laws are violating their First Amendment religious rights. And the Supreme Court stayed out of that case. It's another case that the Supreme Court did not want to touch this year over the objections of Justices Gorsuch and Alito and Thomas. In April, the Third Circuit unanimously ruled against Catholic Social Services, and I think this is another, we talk about these cases every year on this panel, but these religious dissenter cases and the collision with civil rights laws, I think this is another one of those important cases. The other thing, just quickly, on the abortion cases, which I know I've got 1 minute to do it, but this is another area where the US Supreme Court just pretty much put a paper bag over its head, didn't want to deal with what's becoming a significant pileup of reproductive rights cases. They really now at this point have enough on the menu that they could do nothing but decide abortion cases. What they did do was June Medical Services. That was the case that came up from Louisiana. It involved almost functionally the same law that the court had struck down in Whole Women's Health. This was an admitting privileges law that said that physicians who perform abortions need to have admitting privileges at a hospital 30 miles away from where they practice. This was pretty much exactly the same as the Texas law that the court had said didn't rationally have a correlation to women's health, and that the state's reason for saying that they wanted that in place was pretextual. Nevertheless, and a Louisiana lower court judge, in a really capacious fact-finding enterprise, 116 pages, trying to describe what the doctors in Louisiana had to go through in order to try to get admitting privileges. The finding was that 2/3 of the clinics would have closed in Louisiana. 70% of women in the state would lose access to clinics, but the Fifth Circuit said it's okay. And they essentially, I think, got out ahead of their skis, more or less, saying that Whole Women's Health wasn't applicable to the facts in Louisiana because they did different math, and also, I think, a real implication that the doctors had not sought those admitting privileges hard enough. This looked as though it was another one of those cases that looked as though the Supreme Court had to do something because the clinics were actually going to close if that ban had got into effect. And the Supreme Court got this emergency petition by a 5-4 decision this winter. They said they blocked the law from going into effect. They did not get to the merits. John Roberts votes with the liberal justices again, I think, saying nobody overrules us but us. And Kavanaugh actually wrote separately for some of the reasons you're hearing today. Justice Kavanaugh wrote separately to say that the doctors should have an opportunity to show that they cannot get admitting privileges and that the clinics will close. And I think the last thing that I would just say on reproductive rights is that you all know that in the wake of Justice Kavanaugh being seated, we've seen state after state pass what purport to be all-out abortion bans, with Alabama being the foremost, that just criminalizes all abortions for everyone without exceptions for rape and incest. But similarly, Ohio, Kentucky, Georgia, similar bans being passed. And these are all efforts to force this issue onto the Supreme Court docket, sort of predicated on the idea that we now have 5 votes to overturn Roe. It goes to Erwin's initial comments about stare decisis and precedent. But I think that there are, those cases are being challenged by Planned Parenthood and the ACLU. Those cases are working their way up. But I think that it is fair to say that the court can't not decide one of these cases.
Right. Before we open it up for questions, Erwin, do you want to just spend a minute also mentioning the Montana school tax credit case for next term?
The case is Espinoza versus Montana Department of Revenue. Montana's legislature adopted a law that gave tax credits to individuals in Montana who gave money to a school tuition organization. This money then was used and could be used for parochial schools. In fact, a strong indication that the Montana legislature adopted this tax credit program so as to be able to help fund parochial schools. The Montana Supreme Court found that this violated the Montana Constitution. The Montana Supreme Court said the Montana Constitution prohibits both direct and indirect government aid to religion. The Supreme Court granted cert at the end of June as to whether or not the Montana Supreme Court decision prohibiting this aid from going to religious institutions violates the United States Constitution. This goes back to a Supreme Court decision from 2 years ago that we discussed on the stage, Trinity Lutheran of Columbia, Missouri versus Comer. It involved a Missouri program that gave aid to schools to get surfaces for playgrounds. Missouri would give the aid to any public or secular private schools, but wouldn't give it to religious schools. The Supreme Court held 7-2 that denying the aid to religious schools violated the Free Exercise Clause of the First Amendment. But Chief Justice Roberts, who wrote the majority opinion, in footnote 3 said, this is a case about aid to playgrounds and nothing else. We all talked at the time about, could it really just be a case about aid to playgrounds? After all, Chief Justice Roberts also said, denying aid to religious institutions that goes to secular private institutions has to meet strict scrutiny. This is the case that we'll really see, is Trinity Lutheran just about aid to playgrounds? Now, to put this in just a bit of historical context, when George W. Bush became president, he created an Office of Faith-Based Programs to facilitate churches, synagogues, mosques getting federal social service money. This was called charitable choice at the time, and the ADL was tremendously involved with it. But then the question was, may the government give social service money to religious institutions when it's giving it to secular institutions? Here the question is, does the Constitution obligate the government to give money to religious institutions when it's giving it to private secular institutions? And I think there very well may be 5 votes that require the government to do this. But that's what we'll see in this case next term.
Thank you. So I'm going to open it up for questions that have come from the room and across the audience watching live stream. Thanks to Washington Counsel Michael Lieberman for monitoring these questions. First question. In the gerrymandering cases, the Chief Justice determined that no manageable standard exists on which to evaluate partisan gerrymandering cases at the federal level. But how and under what circumstances can partisan gerrymandering cases be argued at the state level?
So, that's a great question, and I think the answer to it is that we'll see. And, I think at first blush, and this goes back to a procedural ruling that the Supreme Court made, I think, last term, where in a case arising out of Pennsylvania, where there were claims under the state constitution, and there was a plea by the legislature for the Supreme Court to get involved, even though the map was being invalidated on state constitutional grounds. In the Pennsylvania case, the Supreme Court stayed out of it. And so I think if you looked at that and just took that as, at face value and then just read the majority opinion, you might say that, well, these issues are really going to be left to the state courts. Mm-hmm. But I don't know, Erwin, wouldn't you may have said the same thing about some of these Trinity Lutheran issues, which is to say, well, the Supreme Court has said that at the federal level, the federal Constitution doesn't require the exclusion of religious organizations, but if the state wants to do that under the state Constitution, maybe as a matter of federalism, play in the joints, they can do it. So I would just say, that's why I say I think the answer is we'll see and it depends, because at first blush, you might think that principles of federalism would really make those cases different and keep the Supreme Court from really getting involved in those cases. But there may be more to it than meets the eye.
I think it's a good point, but you've got to remember, states always can protect more rights than the United States Constitution. And so if Pennsylvania wants to say that partisan gerrymandering violates the Pennsylvania Constitution, it can do so. If Florida wants to say partisan gerrymandering violates the Florida law, it can do so. And what's different about what you're saying is, in the religion context, the Supreme Court is saying what the state is doing is violating the U.S. Constitution. And I don't think there's a basis for the Supreme Court to say that stopping partisan gerrymandering violates the Constitution. The other thing that I'd point out is states, in the rare occasions where they do this, seem to have no trouble coming up with standards when partisan gerrymandering is impermissible. Pennsylvania's done it, Florida's done it. Not sure why the Supreme Court couldn't follow those standards too.
Anything else to add? So, turning back to the census also, next question. I asked what would happen if it reached back to the Supreme Court, but what happens if the president has the citizenship question inserted via executive order? Constitutional or not?
You're our census
No,
expert.
I mean, it was really interesting. I mean, I'm interested in what Paul thinks. I think that there was, Hugh Hewitt put his best argument forth. Michael Ludig put his best argument forth. I think those are not great arguments, but that you can do this by way of executive order. But I'm much more interested in what Paul thinks.
Well, here too, though, I think you have to distinguish the question of whether you can do something like this through executive order, where, without having studied it, I would think there'd be a pretty good argument that, well, sure, in the abstract, this is the kind of thing that the president could do via executive order. But then there's the real question, which is, okay, but can you do it through this executive order at this point in time, given everything that's come before it? And I do think those are really very different questions. And suffice it to say that lawyers, going back to the cross and all of that, lawyers don't always get to pick their fact pattern. But I'm guessing that there are a lot of fans of executive orders that wouldn't necessarily pick this particular context to tee up the question about the scope of the president's power under the executive order.
The Census Act assigns to the Commerce Department the responsibility for designing the census form. The Commerce Department has to follow the Administrative Procedures Act. Can the president, by executive order, then circumvent what the statute requires and what the APA requires?
And again, I think that's maybe a difficult question under the best of circumstances, but I do think it's again, if at the very beginning the executive branch took the position that at least on this question, that, they were going to proceed by executive order, and they had a sort of a theory from the get-go as to why that particular act either didn't apply to this particular question in this particular census, or that particular act was a restraint on the Article 2 branch that was constitutionally problematic. And so from the very get-go, they said, we're not going to do this the way that other administrations have done it previously. We're going to do this via executive order. I think that's one case. I think having gone up to the Supreme Court, produced the particular decision they produced, make representations about June 30th being a critical date, and then sometime in July, coming up with an executive order, I think that's a very different and a much more difficult case for them.
I will say there's been at least chatter that I've heard in the last 24 hours suggesting that you can just make this a straight up an immigration emergency. and get yourself onto, so use the rationale of the travel ban, which is that this is exactly the thing that it was represented not to be, and that this is about some catastrophic immigration problem, and that's the way to put it back into the world of what is a permissible executive order. And it's an amazing circle to get back there, but I have certainly seen that speculated.
But again, I think it's the stutter steps along the way that make this much harder. The one we didn't even talk that much about is that the Commerce Department was prepared to sign off on this.
Right.
So that's when we thought it was a done deal. And so it's not as if just the court made a decision and editorialists said that. That's what the actual agency to whom this is confined by statute had decided that they were done.
They're doing this as an addendum. You know when you go to the theater and they clip a thing on that says, like, the role of Paul Clement today will be played? That's what they're talking about. They're saying they're printing the forms and they're going to add this on. And it starts to become almost a parody of kind of last-minute juggling. And so in a way, I think everything that took 2 years to happen in the travel ban in terms of reissuing, cleansing the animus, figuring it out, doing the studies, all of the bulwark that said, no, this is now not what those anti-Muslim tweets were, this is now a really good thing for national security, is as Paul says, it's being urged in the span of 2 weeks.
Right. The next question actually draws on this theme that I'm picking up too, is that the court's focus on, or the role that improper or impermissible motive is played in the decisions on executive policies over the last 2 years. The question is, in their dissent to the Census case, Justices Thomas and Alito raised the concern that the decision will open the door for federal courts to question any controversial decision on an executive branch policy. Do you think these concerns are valid?
Well, the concerns are valid that somebody will raise that question, I think, sure.
Right, sure.
In some ways, I think that was an opinion that was arguing to one half of Chief Justice Roberts' brain, the side that said what Paul properly described as a strong Article II power, strong executive position, and that concern that this is just planting seeds for questioning at all times. Mm-hmm. But there is the other side of the Chief Justice's brain in terms of rule of law and in terms of legitimacy of the process that I think will allow those questions to keep coming up.
Mm-hmm.
There are many areas of law where motive matters. In constitutional law, for example, the purpose of the government matters in terms of whether there's an equal protection violation. Under the Administrative Procedures Act, which is really what the Census case was about, the government can't act in a manner, that an agency can't act in a manner that's arbitrary or capricious. That inherently is going to look at motive. Now, the arbitrary and capricious standard is very deferential to the government, but it still makes motive relevant. And I don't think the court in the Census case was changing administrative law in any way. I think it was Chief Justice Roberts and the 4 liberal justices saying that there wasn't a valid justification here, so it didn't meet the requirements of reasoned explanation under the Administrative Procedures Act.
The next question focuses on public confidence in the judiciary. We touched on it a little bit, but the question states, what can the panel add to the sentiment that the court members have essentially moved from more moderate to more extreme views, and the fact that the public confidence in the court system overall to be apolitical and neutral has decreased?
Erwin says the thing every year and he hasn't said it yet. So I'm going to cite Erwin every other year for the proposition that it's incredibly destabilizing to have a court where every liberal was seated by a Democrat and every conservative was seated by a Republican. And that with, the rancor of, the Merrick Garland events, and then the Gorsuch hearings, and then, the sort of rancor cherry on top was the Kavanaugh hearings. And I do think that there is a massive public feeling that the court now has 2 teams. I think that, as Erwin said at the beginning, that was really not proven up by the ways that we saw the decisions split. And I think in some ways it was a heartening term for people who expected 69, 5-4 decisions there are the two Trump justices are not the same. And so I think those are good signs. But I think in the aggregate, we have an incredibly polarized political court. And I think that the public is very, very concerned, particularly about the level of acrimony and the discourse. And so it seems to me that this is another, if this whole event could have a sort of one encapsulating sentence, it's poor John Roberts. And I think poor John Roberts has inherited the sort of dual role of preserving all of that integrity, having to push back on the president when the president goes after Obama judges. And at the same time, if Trump would just get out of his way, Roberts could have everything he wanted in the world. And that's, I think, a very, very complicated thing. It's a complicated thing to explain, and it's a complicated idea for the public to hold. But I think that the best thing the court could have done was stay off A1 pages, and ironically, they did that until July.
Any others? So another theme that had come across, and Paul, you touched on this, is that a lot of, or some of the recent decisions also raise questions over standing, and perhaps we should expect more on that next term. Do you expect any major formal challenges or changes to who has standing?
Well, look, I think standing is an issue where there are probably 5 votes now to be very demanding about standing and to apply a pretty rigorous test about whether you can get into federal court in the first instance. And that, that may not manifest itself with a 5-4 majority in every single case. And you saw that in the Cross case where Justice Gorsuch emphasized the standing issue, but other of his colleagues got past that. But I think that's an issue where there are 5 votes, I guess, I would say, that are pretty clearly standing skeptics. And that's something that I think you sort of have to take into account in thinking about litigation. And I think we will see probably, I don't know that it's the kind of thing where you'll see an obvious one case that will be like a big, big new test for standing. But I think it'll be a recurring theme of this court that there will be standing issues injected in cases that you might not have seen in other cases. And sometimes those can create some kind of odd patterns. I mean, a case that I was involved in that we haven't talked about for good and sufficient reasons, but was a case where a very odd 5-justice majority found that the state legislature did not have standing essentially to try to sustain the validity of the legislative maps that they had crafted and under which they were elected. Now, I argued the other side of that, so I have my views, but that seems like a not obvious standing ruling, and I think it was an unusual collection of justices, and I think that's going to be the kind of thing that we'll see, that each term there'll be a case that we think the court's going to say something about on the merits, and I think about once a term we'll be surprised that they don't get to the merits. I think that is going to be sort of fueled by at least 2 things. One is, I think that in some cases that will be the preferred mechanism to duck some really controversial issue that would split the court 5-4 on the merits by coming up with a mechanism to essentially duck the issue. That's what you saw in the Gill case about partisan gerrymandering last term. But the other thing, and this circles back to the question about institutional integrity and the rest, I think where you're most likely to see sort of Chief Justice Roberts take a relatively conservative position is where his judicial conservative instincts line up with his institutionalist instincts. That kind of duality. And if they both cut in the same direction, I think you'll have a pretty strong predictor of how he votes. And so I think he's somebody who, as a genuine kind of philosophical matter, thinks that the bar for Article III standing should be relatively high. And if there are cases where that view keeps the court out of a controversial issue, I think that's going to be a case where it's pretty likely that he votes and then maybe a majority of the court votes for there not being standing in a case.
Just to state the obvious, this is a court in transition. And the recent years we've done this program, we've had a better sense of 9 people who'd been together for quite some time and had sort of frozen into certain blocks, not always the same blocks on every issue, but you could sort of see how they played out. It's often been said that when one new justice arrives on the court, it doesn't just change the relationships of that justice with the other 8, obviously, but all of them with each other. Each person changes the dynamic, and adding 2 certainly begins to change the dynamic. So to a certain extent, we're trying to draw conclusions as the train is moving right in front of us, and we'll learn a lot in the next few years. But this is clearly, and yes, there is, to be sure, 5 very conservative justices at this point, and that is a working majority on certain kinds of issues. But I think we shouldn't underestimate the role of transition and what's going to happen over the next couple of years as they find out who they're going to be, who this new court is going to be.
Right. So on that thought, sort of opening it up to all of you for final thoughts, conclusions, predictions for next term. We specifically got a question on the 3 Title VII cases that Dahlia spoke about, predictions for that, DACA, the religious exemptions. So just, and just that broad question, just some final closing predictions for next term, if you have any.
It's going to be an amazing term.
Well, now that is a safe prediction.
This term, there were a couple, maybe a few high-profile cases. But when you think of all of the things that we've talked about, and even some we haven't, and the docket's probably, well, they took 50 cases already, so maybe that's 2/3 of the docket. If you're kind enough to invite us back next year, we're going to have a lot to talk about. And to follow up what Fred said, it's also going to give us much more of a sense of the current Roberts Court and what it's going to be doing.
Right. Any others?
I mean, I think that's right. And to pick up on a theme we've talked about, I think with another year of data, I mean, we don't even have one full term of Justices Gorsuch and Justice Kavanaugh on the court together. So, I mean, we're really going to have a much more robust data set next term. But I think what you've already seen is, these are not the Georgetown Prep twins that are looking at every issue in the same way. And I think those, differences are going to be incredibly important in understanding the dynamic of the new court. And, the reality for litigants is, as somebody who spends a lot of time litigating in the Supreme Court, I sort of define the role of a Supreme Court advocate as getting to 5 for your client. And if you're trying to get to 5, you really have to, and if you have a case where, one way to get to 5 is to keep the 5 conservatives together, but the other way to get to 5 in a lot of cases is going to be to try to figure out a way to get the more liberal justices and peel away one of the conservative justices. And I think studying the differences between Justice Gorsuch and Justice Kavanaugh and how 2 people who everybody's going to identify as judicial conservatives view certain issues differently, those are really going to be the key as a litigant to try to figure out, all right, what's my angle to peel off kind of one or the other sort of subcamps within the 5 more conservative justices. And in some cases, as we've talked about, the way to get to 5 is going to be through the Chief Justice and appealing to those kind of more institutionalist sentiments. But in other cases, it's going to be these, subtly different, a little bit more of a libertarian streak in Justice Gorsuch when it comes to certain criminal law cases, a little bit more of an incrementalism that seems to come out in some of Justice Kavanaugh's writings. Those are really going to be the absolute key things, I think, for litigants to try to figure out, okay, how do I get to 5 with this new court in transition?
Conclude.
No, I would just say there are so many things we didn't talk about. We didn't talk about sort of attacks on the administrative state and agency deference. There's just so much. We needed 3 more hours. But I do think that, ending the term with everybody angry at John Roberts is a little bit of a useful frame for me, because I think it means that not everybody got exactly what they wanted, and it means that there is an institutional actor in place who really cares about optics. And the idea that saves anything is obviously quite transcendently worrying if you feel that there are catastrophic losses on the horizon. But I think there is really something of value in the fact that the Chief Justice has been just a very, very careful steward of the court's integrity and reputational interests this year, and that It worries me that we live in a time where John Roberts decides the future for all of us about everything. But I also think that if this year was any indication, for all the reasons you've heard, I think that he does so, with great care. And in a moment where optics don't matter to anyone at all,
Right.
the idea that there is still an adult in the room is not a trivial thing for me.
Fred, anything?
Last word.
Yeah.
So I think my colleagues, having made very important observations about the court, let me broaden the lens for the final word, which is that I don't know if this is a good or a bad thing, but I believe this is true, that exactly for the reasons that Erwin said, it's going to be a very exciting, monumental term, you're going to have a lot of very important issues being decided right in the heart of what is sure to be an incredibly contentious presidential campaign. We know in 2016 that there was a very high level of interest among voters who wound up supporting President Trump, what his views would be on the Supreme Court. That rated very high in terms of their concerns. My strong sense is that that's going to be high on all sides in 2020, and the court dealing with issues of abortion rights, dealing with issues of LGBTQ issues, very hot-button social issues, issues of religion, issues of immigration, is going to be unavoidable in the campaign. And as I said at the beginning, I don't know if that's a good thing or a bad thing, but I do know there's going to be real heightened interest, I believe, on all sides in the 2020 presidential election, and the court is going to feed into that in the spring of 2020, whether it wants to or not.
So I do wish we could be talking up here all day, but we'll have to meet again next year in the midst of all of this. Thank you again to our esteemed panelists and the National Constitution Center for hosting us. We know the next days, months, year will be critical moments. I think if there's anything we all can agree on, sentiment-wise, that we understand from this year, I hope it's that courts matter, and so this is incredibly important. And I look forward to debriefing with all of you again next summer at the Supreme Court Review. Thank you.
Thank you for